In today's video, we turn back to the question of physician prescription online, but this time we'll be focusing on comparing some of the telemedicine laws across different states. Hi, I'm Michael H. Cohen. I'm founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate healthcare and FDA legal issues so you can launch or continue to scale your health and wellness service or product. Previously on Cohen Healthcare Law Blog, we talked about a couple of different things. First, the legal and regulatory risk exposure of a physician who wishes to prescribe controlled substances to patients in different states. Second, we talked about legal issues for telemedicine platform that markets healthcare and wellness services to consumers and connects them to a network of medical doctors. Third, we discussed a variety of legal issues from medical licensing and telemedicine rules to the good faith in-person prior examination to supervision of nurse practitioners and registered nurses to privacy and security and HIPAA to informed consent practices to general risk management. We also talked about FDA and FTC issues for the telehealth platform promoting online prescription for different health conditions. Today, we're simply going to go through a bunch of statutes from a variety of states to give you the flavor, the aroma for how these laws are configured. Now let's start with California. In California Business and Professions Code, Section 224A, this was in fact amended recently, relatively recently, to liberalize telemedicine policy. It now states, prescribing, dispensing, or furnishing dangerous drugs, as defined in Section 4022, without an appropriate prior examination and a medical indication constitutes unprofessional conduct. An appropriate prior examination does not require synchronous interaction between the patient and the licensee and can be achieved through the use of telehealth, including, but not limited to, a self-screening tool or questionnaire, provided that the licensee complies with the appropriate standard of care. Okay, that's a lot. But notice that second sentence. It allows what the first sentence formally seemed to prohibit. Let's read it again. An appropriate prior examination does not require a synchronous, meaning same-time interaction, between the patient and the licensee, and it can be achieved through the use of telehealth, including but not limited to a self-screening tool or a questionnaire, provided that the licensee complies with the appropriate standard of care. So the not is important. You're allowed to do it as long as you comply with standard of care. By contrast, let's look at some other state laws. Note, these might be amended by the time you watch this video, so our intent today is simply to give you the flavor again of how idiosyncratic they are by state. This next one is from Arizona, 32.1401, 27, T, that's what lawyers have to read. Unprofessional conduct includes the following, whether occurring in this state or elsewhere: prescribing, dispensing, or furnishing a prescription medication or prescription-only device to a person unless the licensee first conducts a physical or mental health status examination of that person or has previously established a doctor-patient relationship. But then, as in California, notice the next liberal sentence. The physical or mental health status examination may be conducted during a real-time telemedicine encounter with audio and visual capability, unless the examination is for the purpose of obtaining a written certification from the physician for the purposes of Title 26, Chapter 28, which has to do with marijuana. So you can do it by audio-visual means. That's the bottom line. Next, Colorado, like many states, it allows occasional consultation by an out-of-state physician, but not unlicensed practice, so you don't have the same allowances. And last, from Washington State, very liberal as you might expect. Prescribing medications, whether in person or via telemedicine, is at the professional discretion of the practitioner. The practitioner, in accordance with current standards of practice, must evaluate the indications, appropriateness, and safety considerations for each telemedicine prescription. This is not a statute, but a rule from Washington State Department of Health. Yet it goes on to say telemedicine prescriptions entail the same professional accountability as prescriptions incident to an in-person contact. Where appropriate clinical procedures and considerations are applied and documented, practitioners may exercise their judgment and prescribe medications as part of telemedicine. Be especially careful. Considerations would apply to DEA controlled substances, compliance with all laws and regulations to such prescriptions as expected. Measures to ensure informed, accurate, and error-free prescribing are encouraged. So those are the rules. If you're interested in an early read on your healthcare business model, you might benefit from having a legal strategy session with a member of our legal team, which we describe on our website. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com, to send us a message or book an appointment. As always, we're here to help, and we look forward to working with you soon.